Hello, everybody. I hope you can all hear me and see us through your computer screens. Welcome to our second Court of Protection seminar, which is titled Court of Protection and Public Law Issues as the Lockdown Continues. This event is a collaborative and interactive panel discussion. And the way we've organized this event is the program has been developed by yourselves because we asked you to put questions to us in respect of issues that you wanted to hear us talk about and ask questions about. And so the whole program is devised by you. So to that extent, we've got a couple of questions and answer sessions dealing with managing contact in the shutdown period, Care Act duties, the new DOLS guidance, implication of Mr. Justice Hayden's decision in the Surrey case, and other issues about legal protections to be buried in accordance with religious traditions. So it's a wide-ranging program that we've got here today. We want to keep it interactive, so if you have any questions, do put them to me via the chat function, and then what I'll do is I will then read out, subject to how many questions we have, the person who's asked the question, then you perhaps can unmute yourself and then ask the question directly to the panel, just to keep the whole thing quite fluid and interactive rather than us just sitting here talking to you guys. So without further ado, I'll hand over to our first two individuals on the panel to talk about managing contact restrictions during lockdown and social distancing in self-contained flats within the supported living scheme. And so for that, I'll hand over to Sophie Hurst and Eliza Sharon.
So hello everyone. When we met a few weeks ago on Zoom, it was very much at the beginning of these restrictions, and I gave a brief talk on social distancing and how that may affect contact for people that lack capacity. And just to recap, what I was saying in that talk was there's likely to be different frameworks for care homes who are tending to exclude all contact from external visitors in accordance with the government guidance, and supported living providers where there's slightly more flexibility, and obviously people living in their own homes. And the thrust of my talk on that occasion was that it's still necessary to assess capacity and make a best interest decision when looking at contact restrictions. But in all reality, a lot of contact decisions are likely to be guided by what the care providers are willing to tolerate. And we saw that very much in the decision of Mr. Justice Hayden in the Surrey case, which came out around the time of the last seminar, where we see a creative solution being devised in respect of contact in terms of P being taught how to use interactive media and Skype to communicate with his loved ones. But also crucially—
Helen Dandridge, join the meeting.
Also crucially, one of the issues raised in that judgment was family members saying, right, if I'm not going to be able to see my loved ones, I want them to come home with me, particularly given the risks that are presented to people living in care home settings. And certainly that's one of the best interest decisions that I think we're likely to be faced with in the Court of Protection as this issue goes on. And I've seen it coming up in many of the cases that I'm dealing with. Sophie's going to talk a little bit about how she's been dealing with the issue of contact restrictions in some of her ongoing cases. And then we're going to have a bit of a deeper dive into some of the guidance and the regulations.
Yeah, so I think what the Hayden judgment sort of was saying, and what all the guidance we're getting is, it's all about being creative when it's coming to contact at the moment and doing things within what care homes will allow. I think ultimately, unfortunately, with the situation we're in at the moment, we're very much at the beck and call of the care homes and what they're going to allow people to do, because at the end of the day, it's their staff who are putting themselves at risk, and indeed, depending on the setting of the care home or the placement, other residents as well. So I think it's all about being creative and also working collaboratively, and certainly there are a number of ways that this has been done. So using things like FaceTime and Skype, methods such as that have skyrocketed in terms of how people are using those sorts of things. Additionally, though, where care homes can explore people still visiting, you know, that option can remain open. For example, whether back doors, fire doors can be used, safe distances, maybe people meeting in garden areas, people having their temperature taken when they arrive. And these are all questions and things that are certainly worth exploring in discussions with local authorities, in discussions with care homes and care providers, when trying to come up with ways that people who find themselves in difficult situations, such as in the Hayden case, where, you know, we're faced with an individual who was deaf and was going to struggle with the FaceTime and the Skype side of things, to find these more creative ways of people still meeting each other and having that contact. Not only that, and I think this is what Eliza's going to go on to talk about a bit more now, it's also being a little bit creative and having a think about whether actually we can use the regulations that have been, or in what ways we can use the regulations and the guidance that's been published to argue what is in fact a reasonable excuse in terms of people being able to leave the house, perhaps attend a care home, or vice versa, having go home. And there are some regulations or guidance, I should say, that I believe the police have published just recently, certainly since we last had our Zoom seminar, that touches on what may be a likely reasonable excuse, and looking at those, how we can perhaps fit in P or P's relatives and or P's carers or friends into those likely reasonable sort of categories, if you like. And I think Eliza's going to have a little more look at that with you now.
Yeah, so I think it's important to differentiate between care homes, firstly, who are entitled to say, we're not going to allow external visitors onto our premises, which are private property. And that's entirely in line with the government guidance, which has been published, saying that external visitors shouldn't be allowed into care homes, who obviously have a very vulnerable cohort of residents where infection can pass very rapidly amongst them. For supported living providers, they don't own the tenancy or the premises where P is usually living. It's P's tenancy. So it's not as clear cut as them saying, we won't allow anybody else on the premises. And that allows slightly more room for negotiation with the provider as to what's reasonable in respect of contact. Although they can obviously always say, we will withdraw. We think this is putting our staff at risk, if they think the contact arrangements are not reasonable. But one thing I would invite everybody to look at is Schedule 4 of the Safeguarding Vulnerable Groups Act 2006, which defines what personal care is. Because one of the reasonable excuses for having social contact is to deliver care to somebody who is vulnerable. And under Schedule 4, that's defined as being physical assistance in relation to eating, drinking, toileting, washing or bathing, dressing, oral care, the care of skin or nails, or the prompting or supervision for any of those activities, or training, advice and guidance in relation to them. So this may not be relevant for people in a care home type setting, but certainly in some categories of cases, this is relevant, where, for example, you may have a young person with autism or learning disabilities, where their parents and carers are actually very instrumental in their care plans, in supporting a PBS plan, in prompting and guiding in respect of social stories or how to manage certain aspects of their care. So it may be possible to argue that contact comes into the definition of support for personal care in those situations. The other thing that we've been asked to look at is whether it's analogous with child arrangements orders for somebody to go home for a period of time, or to spend time with their families for a period of time. And Sophie, I don't know if you want to pick up on that point.
Yeah, so the guidance that's been given out about child arrangements orders is very much that actually parents who have shared child arrangements, very much the exception to the normal rule, is that children can move between households. Now, this is very much guidance that has been issued for child arrangement orders, and I don't think we can directly take that as sort of the green light for similar things to be going on in the court of protection. However, what we do have, and what we have had recently, I spoke about just a moment ago, is this recent guidance from police. And what that guidance does say is it provides what are said to be likely to be reasonable reasons for you to move or leave the place where you live. And the very last of the things it says is for providing support to vulnerable people. And now that that particular piece of guidance has been published, it seems perfectly reasonable to look at that, providing care to vulnerable people, as being a way in which it may be possible to negotiate or to justify, and I think it's the justifying side of things that's what we're facing at the moment, justifying being able for P to go home, for example, for a period of time. What the guidance also says, however, is that a move to a new household should be measured in days, not hours. So we're not talking about P going home for going to a new household for a day or 2 days or even a weekend. I think in these cases it's very much looking at more extended period, to whether that's a week, 2 weeks, but certainly these guidelines that have been published by the police recently certainly do give us some way into justifying a move between households. So whilst I don't think we can take the child arrangement orders guidance as read and simply lift that into the Court of Protection, certainly this new guidance from the police does give us some areas to sort of justify those moves between households.
One thing that I think it's really important to emphasise is that moving between houses for children who are subject to child arrangements orders are a specific exception in the regulations, which are provided for as a reasonable excuse. And that's what the guidance relates to. And so that doesn't directly apply to adults that lack capacity. But just picking up on the police guidance that Sophie's been referring to, and we can circulate this to everyone that signed up after the seminar, it emphasises that moving house is a reasonable excuse. And just a quote from the guidance, one illustration of this is moving to a friend's address for several days to allow a cooling off following an argument at home. And noting the regulations allow people to move house, this can mean that individuals can move between households, but this should be a genuine move, i.e. measured in days, not hours. And so if there's some sort of shared care arrangement between P living in supported living, but also going home for periods, that probably would come within the police guidance. Although I think it's important that there is then liaison with the care providers about the additional risk that exposes P to and the support staff, because if anybody in that property is going out to work or essential workers, it may be that P would end up needing to be at home for a much longer period if anyone gets ill in the house, and they need to apply the 14-day exclusion period. And so those sorts of contingencies and risk assessments need to take place before that sort of shared care arrangement is facilitated.
Eliza, Sophie, can I just butt in there for 1 second? I have a question from Stephen Richards. Stephen Richards, do you want to unmute yourself and ask the question? Let's see if this works.
Hello, can you hear me?
We can,
Stephen. Brilliant, thank you. Can I just, Sophie, thanks for that. I didn't realise there was police guidance. Is it from the Royal College of Police or the police chiefs?
So the police guidance, it's from the National Police Chiefs Council.
Okay.
And that's where it comes from. As Eliza said, we'll try and find a way where we can circulate that to everyone after this, because I think it does provide that useful, as I said, just a bit of something we can use to justify those moves. So we'll certainly get that circulated.
Thank you, that's great.
Thank you, Stephen.
One other aspect that we've been asked to comment on, and this sort of ties in with the issue of contact, is how to facilitate social contact amongst residents within supported living placements. And there is actually some guidance on this on the government website that was produced prior to the lockdown, when we had the policy of 7 days social isolation if you've got symptoms and 14 days if you're in a household with someone with symptoms. So it's not directly on point, but I think it still applies. And essentially what the guidance is saying is that it depends on a case-by-case basis on what the nature of the supported living layout is. So for example, if you've got people with self-contained flats but communal, possibly communal kitchen areas or socialising areas, or rooms with communal areas, that would probably constitute a household where people can be treated as living in a household rather than having to isolate in their own rooms. But if anybody contracts symptoms of COVID-19, they should be then kept to their rooms for that period of 7 days. It may be that there are vulnerable residents within the facility, in which case it may be necessary to take a stricter approach as to whether there should be communal interaction within the communal areas or not. If they really are self-contained flats and there are no communal spaces, they would probably be treated as self-contained flats, and the restrictions would apply for each household. But I think it's fair to take the approach that if it would drastically reduce people's living spaces and their ordinary facilities, they can be treated as one household. And that guidance is just on the government website. If you Google COVID-19 guidance for supported living providers, it's all there online.
Great. Thank you very much, both. We don't have any further questions at this stage, but anybody who wants to ask Eliza or Sophie any further questions, just fill them to me, and I'll put, and then you can put them directly to Eliza and Sophie. Thank you very much, both. We'll move on to the allocation of treatment tools. Who gets critical care and treatment is a question that's been asked. Sophie and I are going to deal with that, Sophie Allen. So Sophie, if I ask you to start with this part.
Sorry, I was still on mute. Hi, everyone. Yeah, allocation of treatment tools. As you'll all know, one of the primary concerns of the government and the main reasons for the restrictions on us at the moment was a fear, a concern that the NHS would be overwhelmed with seriously ill COVID-19 patients and be unable to cope. And I'm sure everyone's seen the really harrowing footage that came out of Italy, I think in particular, when there simply weren't enough ventilators and critical care beds to go round. With that in mind, there was quite a lot of what was fairly speculative discussion about how people might be separated into who received treatment and who didn't. I mean, in the last few days, I'm sure you'll all have heard that there's certainly the indications are that it's tentatively hoped that those fears may have been premature, and that fingers crossed there will be enough and are enough critical care beds and ventilators to go around. But of course there could very conceivably be a spike or an increase in demand that might cause the NHS to be overwhelmed at some point in the coming weeks or months. So with that in mind, there clearly have to be decisions, or may have to be decisions taken as to admission to critical care and how those decisions are made, and a framework for that. But actually, in lots of ways, the framework and the guidance that's available is relatively limited, and remains relatively limited, unless anyone on the conference call has seen something that I haven't that's come out in the last day or two. The BMA issued a really, I think, really interesting guidance note a few weeks ago that's been updated since. The COVID-19 ethical issues guidance note. And whilst initially, given that obviously we're here talking about issues pertaining particularly to quarter protection and people who lack capacity, that guidance note does contain a couple of particularly, hello? Is everyone there? Sorry, oh, there it is. Sorry, you can see it there. A couple of particularly, I think, pertinent sections that relate to that. And I mean, not inviting everyone to have to go to the section particularly, but there is some consideration of capacity directly. And it says, the fact, it says effectively, in relation to adults lacking capacity, these prioritisation decisions are not best interest decisions under capacity legislation. The fact that a patient lacks capacity does not import a best interest decision-making model. In short, it says there is no automatic priority for those who lack capacity, and decisions about their treatment should be made in the same way as for all other patients requiring treatment. If there is a need to limit the availability of intensive care for patients because of the COVID-19 pandemic and a critical shortfall in ICU capacity, it would be unethical to apply those limits differently to patients with or without appointed surrogate decision makers or those without particular views, which is obviously a separate issue. And so the way the BMA has approached it, and that there shouldn't be any difference in the way that decisions are made with regards to people who have capacity or lack capacity, but of course it's not that straightforward. And it goes on, the potential conflict for that is apparent a little bit later. I think in the document, it's page 6, where it talks about the potential for direct and indirect discrimination and prioritisation decisions. So apologies for reading out tracks of a guidance note. That effectively, it says, some of the most unwell patients may be denied access to treatment such as intensive care or artificial ventilation. This will inevitably be indirectly discriminatory against both the elderly and those with long-term health conditions, with the latter being denied access to life-saving treatment as a result of their pre-existing health problems. A simple cut-off policy with regards to age or disability would be unlawful, as it would constitute direct discrimination. But it talks about the fact that the BMA foresees if prioritisation has to be given, the best way of measuring that is a capacity to benefit, what they term a capacity to benefit quickly test. And certainly that the BMA takes a view that a capacity, it says a capacity to benefit quickly test would be indirect discrimination. In our view, it would be lawful in circumstances of serious pandemic because it would amount to a proportionate means of achieving a legitimate aim under Section 9 of the Equalities Act. Which is interesting, obviously an interesting stance, and that insofar as that's a dichotomy, that's sort of brought into focus with the guideline that was issued by NICE a few weeks ago on critical care and COVID-19, and I think that was issued in mid-March, and there was very, very quickly challenged. Attempt at JR was made, and it was quickly amended. And this is the most update document that's been produced. It is the amended document, but initially the reason that it was subject to challenge was because, as I understand it, in you see the assess frailty box. I think I'm hoping that it's on the screen.
Sorry, I haven't been able to update it, Sophie. There are
No,
slightly limit. Is it
no,
there?
I think that is the updated one, isn't it?
Oh, so you can see the nice critical care admissions flowchart.
Yes.
Oh.
I hope everyone else can see it too. So yes, so I think that's the most up-to-date version, the 27th of March version. The difference with the earlier version was because you'll see in the assess frailty box on the face of it there, which is effectively the first step in considering a referral to critical care, that there's a frailty assessment to be made under the CFS, and then underneath it, that's for patients over the age of 65, and underneath it you'll see any patient under the age of 65 or patient of any age with stable long-term disabilities, learning disabilities or autism, is to have an individualised assessment of frailty. Now, I think in the original guidance that was issued, there was no individual assessment of frailty, it was just assessment on the CFS. And the challenge that was prompted was to the effect that many healthy people with long-term disabilities under the CFS will come out with a score of 5 or more, 6 or 7 perhaps, even though they're otherwise very healthy, and therefore under that flowchart they would automatically ended up in the more frail box and potentially effectively sort of be fast-tracked to not having access to critical care. So there was this amendment that means that anyone under 65 or anyone with long-term disabilities has to have an individualised assessment rather than a CFS assessment. and insofar as the guidance goes, I think that seems to be it. It's certainly anticipated that the clinical commissioning groups and trusts are going to be issuing their own guidance. I haven't come across any of that that's been published yet. Again, other people may know differently, but I couldn't find any. So really, at the moment, and you'll certainly see from the guideline, that actually it's fairly vague, and it's being left very much up to an individual clinical assessment. And the other sort of particularly pertinent matter, which again I'm sure you will be aware of, is that not on the back of that, but at the moment there are, I think, at least 2 applications proceeding or in the preliminary stages for judicial review on behalf of individuals with disabilities, because there isn't any national government guidance or national framework really for making critical care decisions, and there's a significant concern on the part of a lot of disabled people that in the absence of a national policy framework, there's going to be discrimination against disabled people. I think that Sam has got some views on the viability and the receptivity you might get to JR applications in the current climate, and I think it's also going to talk a bit perhaps about the legal principles governing medical treatment cases and JR cases in these circumstances a bit more generally. Sam?
Yeah, thank you very much, Sophie. Now, I think if everyone can see the BMA guidance that Sophie was referring to, we've highlighted the particular paragraph there, and Sophie talked you through it. This is, in my view, a very superficial analysis as to determining whether someone gets treatment or not. Here they're saying that it doesn't really matter if someone lacks capacity because it's a prioritization decision. Now, I say that's superficial because at the end of the day, it's a treatment decision and a medical treatment decision. So whether or not it's a prioritization decision is, in my view, quite frankly, irrelevant for this purpose. So to this extent, it could be argued that this fudges the question and doesn't tackle head on whether or not when you wanted to treat someone for intensive care, for instance, whether that's the best interest decision, which I think arguably it is. But putting this all against the context of the legal principles, as Sophie was saying, it's probably right to recognize that in a situation where a clinician is being made to make a decision as to whether to provide intensive care or ventilation to an incredibly ill person, if they lack capacity, obviously the same legal principles apply, which are namely this, that first of all, the court's not going to compel a clinician to do something if they don't think that it's in clinically the best interests of the patient to do it. But the other principles are that there is still and remains a strong presumption in the preservation of life. That's pretty clear. It's been stated in case law for over a decade. The relevant questions to ask, though, is whether that particular treatment, and in this context, say ventilation, would be futile. So is it futile? Would it be overly burdensome to the individual patient? And is there a prospect of recovery? So I think the reality is that the clinicians are going to have to make those, if it comes to that, very rapid decisions, asking those questions, which ordinarily, if there was a dispute, and even with the new guidance from the Vice President on serious medical treatment, in some cases those would have been brought to court. But now I think clinicians are going to have to make decisions on the ground. And so, I mean, in my view, whilst there's been suggestion that the government is to be judicially reviewed in the failure to provide any particular guidance, I'll be interested to see what the response of the judiciary is in respect of that, especially this time of extreme urgency. But I wouldn't be surprised if the judges simply said, well, listen, we're just trying to get on and do as best as we can do. And I think the clinicians would have to make the split-second decision in terms of a individual patient's best interests. That's what I wanted to cover on that. And I think the NICE guidance is the one that Sophie referring to earlier is probably the best piece of guidance that's around at this particular stage. There's one question that's come again from Stephen Richards. So Stephen, do you want to unmute yourself and ask the question?
Sorry, it's sort of a question. Sam, thank you for that. You were talking about that as the guidance from the BMA, and actually saying about it is effectively should be a best interest decision if the person lacks capacity. The analogy I was thinking of was like the argument with DNA CPR. DNA CPR, you can argue, is a purely clinical decision, but we have established case law saying it is a treatment decision. And if the person lacks capacity, therefore it's a best interest decision. And crucially, that means there's a duty to speak to the family if at all possible.
Yeah, and consult all relevant individuals,
Yeah, so it's really that, because that's the thing, the Capacity Act has not been changed. So
no, and that's a very good analogy, actually. I mean, the question is in practically and pragmatically whether that can occur, given the capacity to treat test that Sophie was talking about, which is literally, to cut through it, a clinician in a split second making a decision as to whether to treat somebody. And if they don't decide to treat them because of their certain criteria that they don't fulfill, because of age or pre-existing conditions, they'll just pass on the treatment to the next individual. I don't think we're quite there yet for the reasons Sophie outlined. You know, I don't think it's as bad as, thankfully, that has been once anticipated. But if it isn't that bad, then yes, it's akin to that scenario, and they should be technically consulting, but whether they do that or not is another matter entirely. But it's a good analogy, I agree.
Thank you.
Sophie, is there anything else you wanted to say in respect of that?
Oh, sorry, given my picture on my computer keeps on changing. No, I don't think so. No, I don't think so. I think we were talking, and Simon Burrows mentioned it coming down to being potentially a resource allocation issue in terms of if they did run out of ventilators. And that's, of course, absolutely right. And the BMA guidance does make the point that you've got the sort of an equivalence with the organ donation sort of litigation and that case law, and so there's justification from a resource allocation perspective, but thankfully we're not there yet, and hopefully we'll get there.
And that's the BA case, isn't it, against the Secretary of State for the Health and Self-Care, which is a 2018 case, which everyone can find in that guidance at footnote 6. Okay, well, if nobody has any further questions from the panel either, then we'll move on to the next part, which is the revised Care Act duty. And Ariana, you're going to talk about Article 3.
I am. So at our last webinar, we had talked about the overall framework for the revised Care Act duty, which set the new standard for eligibility to receive care under the Care Act as the care which is required to avoid a breach of the person's human rights. Just as a reminder, the Care Act easements are not automatic. Local authorities would have to take a decision that it was necessary to invoke them. And from my own reading of it, I would say that the guidance gives a pretty strong nod to local authorities that they should continue to use their Section 19 powers to provide care and support at the level previously required by the Care Act for as long as they can. However, my understanding is I think local authorities are now increasingly looking at this question as they are facing issues of workforce depletion and increased demand on their services, and looking at whether they may or may not invoke the easements in order to give themselves the ability not to meet the needs of certain people in order to prioritize those who have the greatest needs. So what I'll be talking about today, and going back and forth with Sam, is some of these issues about where the line would be drawn for breaches of Articles 3 and 8, and when care would have to be provided to prevent those breaches from happening. From my perspective, I think the big issues under human rights legislation are going to be Articles 3, prohibition on torture, inhuman and degrading treatment, Article 8, right to private and family life, and Article 14. I have to say Article 14 challenges in this context rarely go anywhere. The Davey case, which I'm sure most people will be familiar with from a few years ago, ran an Article 14 point, ran an Equality Act point for issues where local authorities are very specifically looking at what services are required to meet people's care needs, where the essential reason for providing care is around disability. The Article 14, it doesn't really have much of a life of its own above and beyond the other ECHR cases. Obviously, some exceptions, but very, very rarely. So what I'll be talking about first is around Article 3 breaches. There is a division in Article 3 case law about the positive obligations of Article 3 and the negative obligations. On the negative side, states can't take actions to inflict inhuman or degrading treatment upon the person. This is protected very robustly by the courts. The positive side of the right deals with the obligation of the state to take action to prevent a person from suffering inhuman or degrading treatment, which would befall the person in the absence of such help. The case law, including Pretty in the UK, which went up to Strasbourg on this point, confirms that this includes suffering which flows from naturally occurring illness, where this has been exacerbated in some way by an action from the state. The threshold for Article 3 is very high. Article 3 is typically engaged when the most basic needs of a human being are being denied. If a deliberate action is being taken to deprive a person of housing, food, or basic care, that's very likely to be an Article 3 issue. And there are a number of exacerbating factors which can exist. The case law is clear that mere homelessness, and I don't mean that to in any way trivialize it, but to say that homelessness on its own is not necessarily enough to engage Article 3. However, if there are compounding, exacerbating factors to that, that may be sufficient if you're talking about a person who does not have access to food, access to housing, and is dealing with additional issues such as an advanced age, mental or physical health conditions, and other issues which might affect the person, including weather and the time of year, and whether the person has already been suffering prior to these things being taken away. Again, looking to Limbuela, which I mentioned at our previous webinar, this is really the key case, and it offers a fairly pithy summary of Article 3 and saying the treatment is inhuman or degrading if, to a seriously detrimental extent, it denies the most basic needs of any human being. Now, this has again been considered over the years primarily in the context of people with no recourse to public funds. This is an issue that's regularly gone up to Strasbourg, again, particularly around people who are facing deportation back to countries where they would have inadequate access to social welfare systems and who are already suffering physical and mental health problems, which they were receiving support in the European country. In 2017, the European Court of Human Rights did provide further guidance on the health and social circumstances which would meet the test for Article 3 as developed particularly in D in the United Kingdom and N in the United Kingdom. In this case, it was a person in Belgium who had multiple health issues, including tuberculosis and leukemia. The court looked at when the exceptional criteria would be met and considered that there would be an issue under Article 3 when you were taking a seriously ill person in which substantial grounds have been shown for believing that the person, although not at imminent risk of dying, would face a real risk on account of the absence of appropriate treatment in the receiving country or the lack of access to some treatment, of being exposed to a serious, rapid, and irreversible decline in his or her state of health, resulting in intense suffering or a significant reduction in life expectancy. So this is, again, not just a standard that a refusal to provide care and treatment may cause the person to reduce their life expectancy, but also that they would be suffering as a result of that. So again, emphasizing that this is a very, very high threshold for care. It's, again, something that's very much exacerbated when people have very limited social support of their own. The cases where there have been found to be Article 3 breaches very frequently deal with people who have none or no effective support in any informal way, such as family members who would be able to care for them, and thus would be left to face the full extent of their suffering in the absence of any help. In brief, the question of Article 3 is always going to be a very fact-specific inquiry, and the question of whether care is required to prevent a breach is going to turn on what level of suffering a person is likely to experience in the absence of care. An understanding of what resources would be available to the person in the absence of care is really critical. And to this extent, even though the Care Act easements do allow for local authorities to forego assessments under Section 9 of the Care Act, my view is that robust assessment of the person will be really key in any analysis to taking a reasonable and rational determination of whether care is required to prevent that human rights breach. Now, something else that's often emerged in the case law around this is a general view that Article 8 is unlikely to be breached in the absence of an Article 3 breach. And now Sam's going to talk to you a little bit about circumstances in which Article 8 may, as a standalone, require care, even if the failure to provide care wouldn't engage Article 3.
Yeah, thanks, Ariana. There are some examples, they're extremely rare, but they mainly and largely deal with family issues. But it's probably important to just step back slightly and just understand the remit of Article 8, because I think the the common misapprehension is that Article 8 simply deals with family and private life. It goes well beyond that based on Strasbourg jurisprudence. And I'm not going to go through the entire list, but some good examples include if there's been psychological damage, physical or moral integrity has been debased, not to the extent to result in the threshold that Ariana was talking about under Article 3, but a lower one. It includes obviously privacy. It includes issues relating to an individual's identity or breaches of their autonomy, and obviously includes their family and home life. And I think a good example as to when, especially in some of the cases that we've been dealing with of recent, of where Article 8 is in play and Article 3 isn't, is cases, for instance, where PE was subjected to ill treatment and assaults, to which they were a victim in a care home or another governmental institution. And the authorities had failed to, in their positive obligation, to protect the individual from damage to their private life. And that the level of severity didn't reach Article 3, but did, in that type of case, can lead to a breach of Article 8. So it doesn't always deal with family life, in short. The threshold isn't as high, and it can deal with moral integrity, is the headline. So there can be circumstances, to answer the question in short, when Article 8 can be violated without Article 3, but they are extremely rare. If I can put back to you, Ariana, what about, from what you're saying, what about situations where there's been a scarcity of resources? How do you think, especially now, that's going to impact on Article 3 obligations?
Well, funny you should ask, Sam. The case of UCH and MB provides a very recent counterpoint on the Article 3 issue specifically. Again, this is a case that came out just before Easter, so very much in the throes of the coronavirus pandemic, which involved an application by University College Hospital for possession of a patient's room. Reading the facts of the case, which I have to add my view is that they're extremely important in any case involving Article 3. This was a patient who had multiple mental health diagnoses and a functional neurological disorder. She was in a small neurological ward, and it was anticipated that this would be needed for patients who may be suffering from COVID-19. From the facts, which again, we can only take them from the judgments we have, this patient appeared to be extraordinarily difficult to manage, to the extent that some of the staff treating her were treated for PTSD themselves as a result of her abusive conduct on the ward. And the hospital had been trying to discharge her for nearly a year. They had put arrangements in place for her to be discharged with a 24-hour package of care for the local authority, but they hadn't actually identified any specific patient who would be needing her room. It was just generally anticipated that she should go from this ward so that the bed would become available in the event that someone would need it in the future. She sought to oppose UCH's application on the basis that it would violate her Articles 3, 8, and 14 rights, specifically because she felt she was at risk of self-harming or committing suicide due to her mental health. Ms. Justice Chamberlain found that there was no merit in her opposition, as he did not consider that she was going to suffer from inhuman or degrading treatment as a result of the discharge, as she was going to have 24-hour care. Notably to me, this case offers a fairly in-depth discussion of Article 3 in times of scarce resources. And what the court found was that Article 3 would not be breached where a hospital refused to treat a patient on the basis that it could not provide care to all who required it, and other patients would derive greater clinical benefit from that care. And from a specific quote from the judgment, it is plain that Article 3 was not designed for circumstances where the challenge is as to a health authority's allocation of finite funds between competing demands. And the court took the view, Ms. Justice Chamberlain took the view, that decisions taken by a health authority on the basis of finite funds are, in my judgment, no different in principle from those taken by a hospital on the basis of finite resources of other kind. In each case, a choice has to be made, and in making it, it is necessary to consider the needs of more than one person. So, interestingly, he actually reached out beyond what he was being asked to decide in this case, and took the general view that a hospital essentially could not breach Article 3 by declining to treat a person in favor of treating another person. It also couldn't engage Article 3 simply by making a resource allocation decision not to offer care to certain people. The court found that it didn't matter that no other person had been identified who these resources would be given to. It could be taken as a matter of general planning. And where the decision to discontinue inpatient care involves the allocation of scarce resource, the positive duty under Article 3 can only be to take reasonable steps to avoid such suffering. Now, if I'm allowed to be somewhat controversial in criticizing a judgment of the High Court, my view is that the ratio in this case is drastically overbroad. What you actually have in this case, what it boils down to, and I have to say, I don't actually criticize the judgment in any way. From the facts of the judgment, what you had was a patient who had no clinical need for the hospital bed. They'd been trying to discharge her for a year. They felt they had nothing additional to offer her on the service. She didn't have a need for health care, was the essential finding of the case. So to that end, she wasn't actually being denied any health care that she had proven that she needed or that the hospital was prepared to offer her. However, the court had found that she was still going to have extreme suffering as a result of her mental health issues from being discharged. The reason she was being saved from that was because she was being discharged to a 24-hour package of care for the local authority, which would have provided extraordinarily robust protection if she did start self-harming or if she did attempt to commit suicide. And to my mind, that was the real decision. That's why Article 3 isn't engaged in this case. It's not engaged because it would be impossible under a positive obligation framework. It wasn't engaged because this woman wasn't going to be suffering. And so to this end, and I have to apologize, I've already been boring my King's Chambers colleagues in discussing this, but now I can bore an even broader audience of people about this. I think there has to be a lot of care taken in this ratio. I do think it's possible to breach Article 3 even in a scarce resource context, because when you're actually talking about the level of suffering that you need to engage Article 3, it's a pretty dramatic level of suffering. And if people are experiencing that, I do think it's possible for the state to fail them by offering them no care to alleviate them from that burden. So to that end, I would say apply this with a lot of caution. I don't think it's just reasonable steps. I think there are people who will meet that Article 3 threshold, and they do need to be protected by the state to the extent the state can. I acknowledge it might be theoretically possible that there could be so many people suffering from an Article 3 level of suffering and deprivation that it could become a scarce resource allocation question. However, I don't think we're remotely close to that. And in this context, I do think a lot of caution has to be applied. Sam, have we been getting any questions about this? Because I seem to keep hearing pings.
Can I ask a question? You've both been talking about Article 3 and Article 8, which are quite high thresholds. What about the positive obligation under Article 5, particularly once the lockdown lifts? This may be in place for almost 2 years. The local authority has duty to bring about or to try and bring to an end any unlawful deprivation of liberty, and if putting in support in place alleviates that, surely that obligation remains as well.
Well, but it seems like that could be largely alleviated simply by going through a DOLS process, couldn't it? Because if the Article 5 breach is put onto a lawful statutory footing, or the putative breach is put onto a statutory footing, then it wouldn't be a breach anymore.
Well, only if someone's in a care home. If someone's at home and they require support to go out and to not be deprived of their liberty in their home, presumably that will engage local authorities' rights under the emergency legislation.
Well, but I mean, I think that sort of brings us back to the question we were talking about last time, to the extent to which we're all deprived of our liberty at this point, because
lockdown, but the lockdown may end in 3 to 6 weeks, whereas this framework may be in place for up to 2 years under the Act.
I mean, it may be, and I think it's a reasonable question to consider. I do think that there would be a slight difference in terms of whether they would have to make a COP application solely on the basis of a person remaining in their house on the basis of a lockdown. To my mind, I think the greater issue around that would probably be under the Article 8 issue, because the question would be whether the person needs support in order to engage their private and family life in some way, which, as Sam pointed out, is beyond merely contact with one's family and does involve a broader aspect of that. What I'd also say is under a Care Act framework, if local authorities are trying to meet Care Act obligations under the Section 19 power for as long as they can, that would include accessing the community and interpersonal needs. So there should certainly be an effort made under that, even if you're not going onto an easement framework, to try to maintain the person having community access to the greatest extent possible.
Yeah, my point was really not about authorising it, but trying to bring it to an end. So under the A and B judgment, the minimum B judgment, I think it was 2010, it was going through the steps that if someone's being deprived of their liberty, the first issue is whether you can bring it to an end through the lack of support, through the provision of support. If you can't, you may need to apply to the court, but only if it's in their best interest. So that would be the justification. So it may be an avenue to argue that support needs to be provided so as to avoid an unlawful deprivation of liberty.
Well, and I'll also look to the silkier member of my panel and see if Sam has any views on that as well.
Yeah, no, I think that's probably right, actually. I mean, I'm just thinking how MB fits in here, because do you think that the judge said that the threshold increases in times when resources are scarce?
Well, I would say he actually went even farther than that. I would say that he says that Article 3 simply does not apply, that the positive obligation is no longer absolute to take steps to prevent suffering. What he said was that it is a duty, the positive obligation becomes a duty to take reasonable steps to prevent suffering, which I have to say, I don't agree with that. I think Article 3 is written as an absolute right. Now, I mean, I think it's complex.
That imports terms which isn't contained in Article 3.
Yeah, and this is why I think it is a problematic judgment on that front, is that I don't. That's not what Article 3 actually says. Yeah. I mean, what Article 3 says is that people shall not be suffering from torture and inhuman degrading treatment, and obviously it's a complex question as to when Article 3 is engaged and what the state's obligations are to provide a social welfare system. And I do fully take on board the Strasbourg case law is very clear that there is no general obligation to operate a welfare system solely for the purposes of around Article 3, and there isn't that very, very clear line. However, where it is always going to be a fact-specific question, and you do have someone who you find is suffering in a level which engages Article 3, I don't see that we're at anywhere near the level of scarcity to where we're actually trying to decide which of the Article 3 violations we're going to fix. Yeah. I think there's because that is such a sliver of the population relative to the whole population. The issue in this case was simply that this was a woman who didn't need healthcare, and taking healthcare away from a person who didn't need it didn't engage Article 3 at all.
Sure. Yeah, so to some extent, there was an easier way around the judgment for the judge, which is to say that it just didn't reach the threshold because her needs are going to be met by way of a package of care at home.
Which he did fine, but he just went on to a much broader discussion, which I worry maybe unduly applied, where I don't think that was actually necessary for the ratio.
Yeah. Can I just quickly ask this? Has anybody had encountered across the whole discussion, and the people listening in, any local authority applying the easements yet? Certainly, I've found that all local authorities are still complying with their with the standard duties to assess and provide support, even if we're delaying when those assessments take place. Just interested to know if anyone's come across the local authorities seeking to invoke the easements.
Go ahead and unmute yourself.
Hi, it's Laura Fox from Darlington Council in the North East. We're not applying the easements yet, but other local authorities in our area are. Middlesbrough have gone to that stage. So whilst we haven't, I'm aware that others in the area are applying them.
And my reading of the guidance is it really has to be a formal decision to apply it across the board, and being able to evidence the depletion of resources and why it's necessary. Again, that in itself, I would think, would be a judicially reviewable decision if the evidence isn't that the resources are sufficiently depleted. People agree?
Yes. Yeah, it definitely has to be a formal decision to take them. It can't be something that's done on an individual basis by social workers as and when. It has to be taken at a local authority level.
And presumably there needs to be some sort of publication about what that decision is and the evidential basis upon which it's been taken.
Including notifying all service users. So there has to be reporting both to government offices, to your local CCG, and to all service users, among other people who would have to be notified about that. So it certainly shouldn't come as a surprise to any service users that this could be happening to them in the local area, because that is part of the duty set out in the guidance.
Okay, well, let's move on to the penultimate topic, which is the new DOLS Covid-19 governmental guidance, which was issued in April this year, and the implications of Hayden J's most recent judgment in the Surrey case. And to that, I will hand over to Simon and Francesca.
Hello, everybody. So there's been some new guidance. I say new, it's 10 days old, which seems like a lifetime at the moment, but it's the Department of Health and Social Care published the updated DOLS guidance to be applied during the pandemic on the 9th of April. I don't know how much of you are all now completely familiar with the guidance. It's relatively uncontroversial if you ask me, not if you ask Simon, who's going to speak after me. But there are some things that we all need to be aware of. The tone of the guidance is definitely one of pragmatism, which is to be sensible, follow the law and do what you can. But ultimately, it's important that we know the key aspects of it and that we're all still applying the law as we should be. So, of course, the starting point is that it's only to be applied now. It's only applicable during times of the pandemic. Sorry, I just heard a beep. I don't know if anyone else did. It's only to be applied during times of the pandemic, but at all times, the MCA and its overriding principles still apply. So if I can just take you relatively quickly through the key aspects. So all decisions, it seems an obvious point, but it's important at the moment. All decisions must be taken specifically for each person. You do not apply decision making to groups of people or to types of setting. It's person specific, and that was certainly demonstrated by the Vice President, Mr. Justice Hayden, in the recent Surrey decision. And I know that Eliza and Sophie have already because he, in that case, he said a number of things, but he said very clearly that I think that P's initials were BP. He had additional needs because he was deaf. So it simply wasn't enough to say for him that he could talk to his family by telephone. There needed to be the involvement of Skype. And the same applies to any assessment and any best interest assessment under Article 5. So we all just must remember that absolutely it's not about the conditions of a certain home or the care and treatment going into a certain setting. It's person by person. What the guidance does say is that it will be necessary in a lot of these cases to change the care and treatment arrangements for somebody because of the COVID-19 pandemic. But it goes on to then say that the changes that are made because of the pandemic are unlikely to mean that further authorization is needed. I personally think that's a bit vague. And I think it's important to remember that what that refers to are cases where you already have a lawful authorization in place. For example, if somebody in a care home or hospital who is subject to a standard authorization then receives additional care and treatment as a result of the pandemic, the likelihood is that if you follow the best interest process, there doesn't need to be a further authorization. What it doesn't mean, quite clearly in my view, is that you can follow the best interest process to deprive a person of their liberty because we're within the pandemic. There needs to be that lawful basis for the deprivation in the first place. It makes what we all know is quite an obvious point now, but an important one, which is that assessors should not be visiting care homes or hospitals unless it's absolutely essential, and that previous assessments can be considered as relevant evidence. Significantly, in many cases, it does say, as I say, that it will be sufficient to make a best interest decision in order to provide the necessary care and treatment. What I'm not referring to there is life-saving treatment. Simon's going to talk about that, as I say, I hope in completely uncontroversial terms, I'm sure not. This is simply in relation to any additional care and treatment that a person might get because of the lockdown measures. The guidance clarifies that in terms of advance decisions and lasting powers of attorney, if there's a valid advance decision in place that covers refusal of treatment for COVID-19, it absolutely applies. Attorneys have the authority to make those decisions if there is a valid lasting power of attorney in place, but that it remains the position that if there is a dispute between the care professionals and the attorney or the deputy about whether or not it's in the person's best interest to receive the treatment, that needs to be resolved in the usual way. and whether that steps will need to be taken, for example, to have a best interest meeting if that's possible, whether it be virtually or by other means, and then there will need to be a referral to the Court of Protection. There is no additional power or authority to an attorney or a deputy in circumstances of the pandemic. In terms of urgent authorisation, and I say that in the general sense of the term, where there is a case where somebody needs to receive care and treatment and there isn't a lawful authorisation in place, a standard or an urgent, we have a new shorter version of the urgent authorisation form for care homes and hospitals to use. And that's of course that can be used. And then in terms of community settings, there was some recent guidance. I don't know if you've all seen it, but we can certainly circulate it if it would be helpful. Some guidance that was approved by Senior Judge Hilda about DOLS 11s. They can be made electronically. There's details of where to send them and when and how the court will try to consider them. Just a little word of caution here, which I'm sure we all know, but in terms of making an application for authorisation of a deprivation of liberty in the community, whether that be to authorise measures as a result of COVID-19 or not, there is no authorisation until this application has been made. Once the application has been made, the court's then considering it, or it's in what is likely going to be a backlog, there is then, of course, the provision of Section 4B, where a deprivation of liberty can occur on the grounds of necessity. I think it's pretty unarguable to say that measures put in place as a result of COVID-19 wouldn't be necessary, but the application has to have been made. Just before handing over to Simon about the treatment, specifically life-saving treatment, the sort of headline final points from the guidance that certainly in my view is, of course, deprivation of liberty still requires authorisation. There is nothing within the guidance that says that authorisation isn't required, although it's a little bit ambiguous. It simply says that if there are additional measures to put in place, then the best interest process can be followed. If there's a significant dispute, and that includes a dispute about contact, the normal rule applies. It is ultimately the Court of Protection to determine those disputes. If a person is already deprived of their liberty and it is already authorised, then additional COVID measures are unlikely to require further authorisation. And in terms of community deprivation of liberty, as I say, the normal rules apply. But if there is already a court order in place that doesn't specifically reference COVID-19 measures, the guidance is clear that it is likely that they wouldn't need further authorisation, that they'll be covered under the order. What I will say to any of you that haven't had the opportunity to look at this guidance, it's an easy read, it's 12 pages, but at the bottom of it is a really helpful flowchart in terms of which sets out quite clearly the cases that would fall within the deprivation of liberty safeguards and the cases that wouldn't. And those are the cases that Simon's going to talk us through now.
Well, hello.
Yes. Sorry, Simon, before you start, I've just got a comment on respect of something that Francesca was saying from Hannah. Hannah, do you want to just unmute yourself to ask the question or make the comment?
Can you hear me?
We can.
Yes. No, I was just letting you know. Wasn't expecting to have to speak. But yes, I
no,
made
it's a pleasure to hear from you.
DOLS 11 application today, and it appears to have been accepted. They are accepting typed signatures on the forms as well. If you don't have an electronic signature that you can use, they appear to be accepting type names. And the naming of the documents is really important so that they know that they have absolutely everything they need to be able to refer it to a judge. That's all really.
Thank you.
Thank you, Hannah. That's really helpful.
Simon, over to you.
Well, I'm going to be very brief. You'll all be very pleased to hear. As far as what Francesca's been talking about is concerned, she's covered really the basic theme within this new guidance. I just want to pick up on two issues in relation to life-sustaining or life-saving treatment and deprivation of liberty, as well as the final part of the guidance, which deals with emergency public health powers, which I'll just briefly refer to at the end. We know, because this is something that has come out in the media over the last couple of weeks, that the care homes have become a repository for people suffering from COVID-19. In other words, people have been discharged from hospitals into care homes without receiving any tests to see whether they have the infection or not. And those who have the infection, it seems, are not being sent to hospital, particularly if they are elderly and living in what we might call generically old people's homes. The need, therefore, for life-saving treatment in care homes is something that has become very clear over the past few weeks. It's been dealt with not only as a thing in itself, but also the resulting need for protective equipment for people working in care homes, who all of a sudden have become barrier nurses dealing with a virus which has a mortality rate which is quite high in that cohort of the population. And so it's within that context, and I think quite deliberately, that one has to look at the DOLS guidance on delivering life-sustaining treatment. And Francesca says I was outraged or something at this. I'm not really. I'm simply concerned that there's another chipping away of the deprivation of liberty definition, which we all value so highly, which was from the Cheshire West case. Because in this guidance, as I say, it is anticipated that a lot of people will be receiving life-saving treatment in care homes. One of the things that's made clear is that the Ferreira test, if I can call it that, which you'll recall was a test which was developed by the Court of Appeal in relation to whether there was a need for a jury inquest in relation to people who die in hospital in an ICU when they're receiving life-sustaining and unfortunately not successful treatment. There was a very interesting judgment from Lady Justice Arden, as she then was, which basically disapplies the Cheshire West definition of deprivation of liberty for those who are in an ICU setting, if the restrictions which are placed upon them would be no different if they were somebody who didn't have unsoundness of mind. And so that is introducing what appears to be a sort of comparator argument, which was the very argument that was rejected by the Court of Appeal in Cheshire West. But it's relevant only to people being treated in an intensive care setting. It is expanded by this guidance, which is not, it seems to me, legally binding. It could be reviewed in the courts, but it extends that to care homes, so that if a person in a care home who, because of their condition, becomes incapacitous because of the effects of COVID-19, then the fact that they are deprived of their liberty under the Cheshire West test, in that they're under continuous supervision and control and are not free to leave, will not be deprived of their liberty, so that there will be no need to obtain authorization for them. Of course, if a patient or a resident is already deprived of their liberty by a standard authorization or an order of the court, then this treatment again will not add anything to it as long as it doesn't fall into the categories that Francesca has identified where there is a disagreement about it, a dispute as to whether the treatment should be administered or not. So that's the first thing. I'm not sure numerically what impact this is going to have, but it's certainly a chipping away at the use of Article 5 rights to protect people who are in any other sense deprived of their liberty as a result of being treated in a care home. Emergency public health powers. We all know that Article 5 has the provision for the deprivation of liberty of people with unsound mind. The bit we normally skip over is the right to deprive people of their liberty to prevent the spread of infectious diseases. Everyone involved in this conference call is probably subject to that power at the moment, although I'm not going to get into that. And what happens when you have public health powers which can be used to stop somebody who is clearly infected spreading the virus? Well, those powers are contained in the Coronavirus Act. Public health officers have powers to impose proportionate requirements, including screening and isolation, but also detention in relation to people who are going to spread the virus. There's an interesting interplay in the guidance between the use of the Mental Capacity Act and the use of public health powers under the Coronavirus Act to try to keep people safe. The person themselves can be kept safe if they lose or don't have capacity, using best interests under the Mental Capacity Act. Don't necessarily need to resort to the Coronavirus Act. People who don't lack capacity can obviously be apprehended under those powers, and that's really what the guidance says about that. There are some paragraphs in the guidance which make me feel slightly nervous, and I'll finish with those, and I'm going to read them to you. They're not very long, and I do read very fast. It says this, paragraph 27 says, where appropriate and relevant, current assessments, oh, sorry, that's the wrong one. It's the paragraph that basically says, it's a sort of nudge, nudge, wink, wink. It says that if you can do the procedures properly, then of course you must. But if you can't, don't worry, because if the person is receiving proper care and you're doing everything you can to make sure that you abide by the Mental Capacity Act rules, then no one's going to be critical of you. You may have read those paragraphs thinking that that's some form of derogation, to use a word, from the rights under the Mental Capacity Act and the European Convention. But of course, you've still got to look at the law and see whether you do need to comply with it by trying to get an authorization. So don't take too much comfort from that, although it looks like it's, as I say, a nudge, nudge, wink, wink. Nothing's going to happen if you don't. So I think, unless you've got anything else to say about that, Francesca, that's all I have to say.
Yeah, in terms of the paragraph you were talking about, it's paragraph 21, if anybody
21.
wants to read it. Yeah, and I think Simon's interpretation of it is rather mischievous. I personally think that the tone, again, is pragmatism, which is that, you know, do your very best. But then when you read that into the rest of the guidance, it's clear that there still needs to be lawful authorization for any deprivation of liberty, and the relevant processes followed. But perhaps I'm more optimistic, and certainly less cynical than Mr. Burrows.
Well, I'm not cynical. Can I just read it? I was looking at the wrong paragraph. It says this: the department, so that's the government, recognised that the additional pressure on the pandemic will put on the DOLS system. Fundamentally, it is the department's view that as long as providers can demonstrate that they are providing good quality care and treatment for individuals, and they are following the principles of the Mental Capacity Act and the Code of Practice, then they have done everything that they can reasonably be expected in the circumstances to protect the person's human rights. And then it goes on to say, where the person is receiving end-of-life care, decision makers should use their professional judgment as to whether DOLS assessments are appropriate and can add any value to the person's care or treatment. Now, it's all right to say you've done everything that can reasonably be expected to protect the person's human rights, except comply with provisions of the legislation that are designed to protect the person's human rights. So I think my reading's probably right, and I suspect no one's going to see any consequences, provided that they fill in the right forms and say they tried everything they could. Having said that, of course, because of the enormous waiting lists for DOLS authorizations, that's probably what was happening already. So anyway.
Can I make a very mundane point or question? One thing I'm getting popping up is people querying whether the courts should start extending standard authorizations past 1 year. I've not read anything which suggests that we can go behind the current authority on that UF, although it's not binding necessarily. What do people think about that? Has anyone extended it past a year? It's certainly cropping up in a lot of cases, I'm finding.
I've never agreed with that. I've never agreed that it should be limited to a year. And I think Charles gave two judgments which said completely opposite things, and people usually rely on the one that says that. But it's to be tested, I think. I think that the way I look at it is that when the court is seized of a Section 21A, it takes over the role of best interest decision maker. And of course, the way that the statute is drafted is that the 12-month period is the 12-month limit on a best interests decision as it is reflected in the in the standard authorization. There is nothing that says the court can't take that over and extend it, provided the court still periodically reviews the legality of detention in the meantime. So if the court says this standard authorization can be extended for another 3 months and it goes beyond the 12 months, I don't see anything wrong with that, provided that it makes the best interest decision then, and there's a date for it to be reviewed within the period that follows. And I think that the law may well be clarified to that effect if an application is made, but that's just my opinion.
Yeah, I mean, I entirely agree with that, because I mean, if you look at UF, he doesn't deal with the issue because he didn't have to deal with the issue. I mean, it was an issue in the preliminary hearing, but it was never issued in the final hearing. So insofar as the people rely on that judgment to say that you can't extend it for a year, I agree with Simon that that's not correct.
One of the issues is sometimes we can get focused in court proceedings on one aspect, say the qualifying requirement of best interest, and you may then go on for over a year without mental health or capacity being reassessed. And so I think if it is going to go over a year, we need to make sure that there is up-to-date evidence on all the aspects of the qualifying requirements.
But when the court considers whether to extend the standard authorization, it obviously has to be satisfied of all the requirements, even if they're not actively in dispute. So I agree with what you say, but that should be what the court does every time. There's like a checklist to go through, a bit like a mental health tribunal, where you go through the criteria, even though most of them are not in dispute. So I think you're right.
Okay, just an eye on the time. Our last question raised by an attendee, which Ariana is going to specifically tackle, is the legal protections for those who want to be buried in accordance with their religious traditions and attendance at burials.
I am keeping an eye on the time, so I'll try to keep this as concise as I can. This was an issue which was raised when the Coronavirus Act was being passed, particularly by representatives of Jewish Muslim communities, about concerns about forced cremations. The Coronavirus Act made provisions for national authorities to designate a local authority area where, as a result of COVID-19, there was likely to be insufficient capacity within that area to transport, store, or dispose of the deceased, which is a horrible way of putting it, but that is the official language. When the area is designated by the national authority, the local authority would have the power to give directions on how deaths were to be managed. And where a regional or national response is more appropriate, the national authority could make those same directions themselves. As far as I can determine, there's at least been no public announcement from DHSC of any local authorities which have been designated as being unable to manage bodies of people who have passed away. And in the absence of any such designation, that would leave existing public health legislation in place under which local authorities must not arrange for a body to be cremated if contrary wishes to if that would be contrary to the wishes of the deceased. Now, even in the event that a designation was made, the personal choice for how a person is to be either buried or cremated must be respected by the local authority as far as possible. And the government has made a statement that the powers of directions will only be used in the most extreme situations where there is a risk to public health, and only when scientific evidence and operational advice suggests that it is necessary to do so. So again, hopefully this is a power which should never come into effect, but even in the event that a local authority was designated in this way, they would still be obliged to give heavy deference in regard to the personal choice of how the person would want their body to be treated after their death. There's also an issue around opening and closing of cemeteries. A lot of local authorities did close cemeteries after the passing of the Coronavirus Act, specifically because Regulation 6.8 of the Health Protection Regulations stated that, quote, a person who is responsible for a crematorium or burial ground must ensure that during the emergency period, the crematorium is closed to members of the public except for funerals or burials. Robert Jenrick specifically said a few days ago that further steps will be taken to reopen cemeteries to ensure that people do have an opportunity to grieve if they have loved ones who have been recently buried. I would also note that Regulation 7 put a general restrictions on gatherings of 2 or more people. However, these do not apply to funerals, but per Regulation 6, it's only a reasonable excuse to attend the funeral of a household member or close family, or that of a close friend if no household member or close family are able to attend. So that's my very brief summary of where the situation stands in regards to funerals and burials.
Thank you, Ariana. That was quite an achievement to summarize that in a few minutes. Does anybody have questions about that particular topic? Please unmute yourself if you do. Okay. Thank you, Ariana, again. Hannah, you spoke earlier. You have another question, so please unmute yourself if you want to ask it. Otherwise, I can ask it on your behalf.
Yeah, I was hoping you would ask it, Sam, in all honesty, but...
I can do if you want, but now that you're on, well, I can do. So, would you like me to ask the question?
Yeah, basically, it's just along the lines of, given the current situation, being that a lot of placements aren't accepting new residents, and with local authority resources being scarce on the ground dealing with the pandemic,
yeah,
is it pragmatic to stay Section 21A challenges, where in the foreseeable future, it's unlikely there will be available less restrictive options for P to consider?
Yeah, it's a very pertinent question. In fact, we've been discussing this between ourselves very recently in an email correspondence. So Simon, shall I hand over to you? What do you think about that?
You can. I mean, my answer is somewhat brutal. The purpose of Section 21A is to ensure that there is a swift determination of a challenge on deprivation of liberty. I know that the habit over the past 10 years has been to make these into full-blown welfare cases going on for months on end. But actually, although I'm not sure the judiciary would do this, it seems to me that if Section 21A comes before a court and the answer is, well, for the foreseeable future, there are no alternative options, then the answer is that the application ought to be dismissed. And I think that that is what the courts probably should be doing. But because of the habit of treating these cases as full-blown welfare cases, it may be that that isn't what's happening, but I think it should be.
Ariana, not to prompt dissent, but what do you think about that?
So it's not dissent in the slightest. It's just adding one other thing in the case of local authorities which have taken the easements. One of the other easements which was made was a suspension of apologize for not knowing stuff about, I believe Section 31 CARE Act, which allows for choice of accommodation for people in specified accommodations. If local authorities have taken the easements, they no longer have any obligation to provide the preferred option for the person, which to my mind, I think has always been central to the question of search for alternative options, because that would have been a power which would have rested with the person to choose a preferred facility. People, for local authorities which have taken the easements, they would no longer have that right. And I think to that end, the local authority could simply say, would be within its rights to say that they aren't exploring any other options because the person has no right to a preferred accommodation. I'm not advising local authorities to do this, because obviously they should try to carry on with CARE Act duties as much as they could. But if they feel that they cannot, that is within their right under the easements.
Can I also make one other point? And this may well run contrary to the point I made earlier on, which most of you will know is not unusual for me. The fact is that at the moment, there may be very good grounds for many people in residential care of all ages, particularly younger people, not just residential care, but also in supported living placements, to go home on the basis that it isn't in their best interests to remain in a communal living environment where they are coming into contact with people perhaps from outside, but also in relation to staff who they're coming into contact inside, but who of course go outside and may well become infected. I'm not saying that that is either a blanket policy either, but I think that every case should be looked at on its own merits. And there will be a number of cases, and I know Sam and I have got one just like this on the boil at the moment. And I think that there is, I don't know whether the courts are actually listening to these, or whether the courts are encouraging a sort of blanket policy of staying everything, because I don't think they should. I think these cases need to be heard. And even if it's over Skype and it's not very satisfactory, they're urgent cases by their definition, and they need to be heard.
Can I come back on your point, Simon, about deferring indefinitely if there's no possibility of a move in the reasonably foreseeable future? At the moment, the government guidance on the lockdown is for 3 weeks at a time. So really, we don't have anything saying that the current restrictions are going to be in place for longer than 3 weeks. And with that in mind, there is the possibility for movement in a short space of time, rather than just resolving Section 21As artificially now to be reissued in 3 weeks' time or 6 weeks' time. And rather than a stay, it can perhaps be helpful just to have a longer lead into directions, so that the action is taken at a point where it's anticipated the restrictions will be lifted.
Well, that was the question I was asked.
Yeah, I was just coming back on the suggestion that you couldn't move within the reasonably foreseeable future. At the moment, the restrictions are for 3 weeks.
Yeah, but we all know that's not going to be the case.
But that's not.
Particularly for people in vulnerable groups. But
yeah,
anyway.
I'm not sure that we can say that that's not the case. I mean, I know cases where there is still movement between care homes. So yes, of course, it's going to be difficult to have an analysis of the available options, but I don't think there's a strict lockdown on moving between care homes. But I think it's like you said, Simon, it will have to be case by case, but I can't see that there would be a blanket approach that, you know, for the foreseeable future, there isn't going to be an option in any case.
Thank you.
But, and sorry, one very quick final point was that the point that Simon made about the balance potentially slightly tipping in terms of whether or not somebody should go home is exactly what the Vice President said in the BP decision. So I think that's certainly something that needs to be looked at in all cases.
Super. We have one final question, a practical question from Sapna. Sapna, do you want to ask the question, or I can ask it for you?
It's going back, can you hear me?
We can.
Yeah, it's going back to whether the standard authorisation can be extended above the 12 months. I've got a case that we've issued a Section 21A to find, when we've issued it, that the wrong supervisory body granted the authorisation. So we're asking the court to terminate the standard authorisation, and in the meantime, the right local authority have put in an urgent authorisation. But they can only extend that above the 14 days. My client, I've been informed by the RPR, may not be very susceptible to video calls and conferencing in terms of creative ideas for the assessments. So it may be a question that we put to the court, is whether the court has the power to extend the urgent authorisation for the standard to be put in place due to COVID-19.
I can see lots of faces saying no.
It's limited to 14 days, I think.
Yeah.
I think that's fairly established. I can't remember the precise authority. I think Cornwall tried to do it in reacts, and they were soundly shouted down by the array of council, of whom there were about 2,000. So I think that's a no-no.
Yeah. Good. Well, I think that brings us to the end of this seminar. Thank you to the panel, but more importantly, thank you to those who have participated. This couldn't have happened if you didn't put questions to us, or it's been a real interactive session. So thanks for all of that. It's good to see you all, those of you who've activated your videos. It's nice to see some familiar faces when we've been locked down here for only 5 weeks. And we're wishing you all to keep well for the future. I should say that I think next Wednesday, and we'll get invites out as soon as we can do in terms of confirming the date and the time, but it is next Wednesday, I believe. The individual who we've been speaking about quite a lot, the Vice President, is going to join us together with the President of the Tribunals, as well as the Liaison Judge for the Administrative Court to the Northern Circuit, and a High Court Judge from the Technology and Construction Court. And we're going to be talking about the rule of law and the importance of maintaining it during this current physical lockdown. So, like I say, the invitation is going to come out, but I hope you can all join us for that informal chat with those eminent speakers. But for now, keep well and good to see you. Bye, everybody.
Bye.